Welcome to the 55th meeting of the Civil Rights Council. The meeting is being called to order. Mario Block, Senior Fair Employment Housing, will call the meeting to order.
Councilmember Hong,
Present.
Councilmember Alude,
Present.
Chair Sandoval,
Present.
Councilmember Walensky.
Present.
Great. Thank you, everyone. I would like to thank the stakeholders who are attending this Civil Rights Council meeting. This meeting is being webcast live via Zoom video conference, and the video of this meeting will also be available afterwards on the Civil Rights Department website and the Civil Rights Department YouTube channel. Please subscribe. We also have closed captioning available for participants, which you can find at the bottom of the Zoom bar features. If you are having difficulty accessing closed caption, you can send an email to the administrator to resolve the issue at council@calcivilrights.ca.gov. Members of the public joining remotely may have noticed that you are currently muted and your video is disabled at this time. Please note that the Q&A and chat functions are also disabled. However, please be advised that there will be opportunities for public comment and participation throughout today's meeting as we address each of our agenda items. We kindly request that you limit your comments to 3 minutes and that you address a specific agenda item. We have a number of ways for you to provide input and comments. Number one, you can email the council at council@calcivilrights.ca.gov. We will be checking this email account throughout the meeting, and your comments will be read aloud and considered by the council members. If you would like to speak directly rather than through an email, please click raise hand in Zoom or press *9 if you have called in. If you would like to rename yourself in the Zoom list of participants, you can find yourself on the list and click rename in the list of options next to your name. As already mentioned, please note that neither this Q&A nor chat function is available for public comment. And once again, we kindly request that you limit your comments to 3 minutes. Department staff members, we would like to acknowledge at the outset, starting with Adam Romero, Deputy Director of Executive Programs, Rachel Langston, Assistant Chief Counsel, Mario Block, Senior Fair Employment and Housing Council, as well as I want to thank everyone who is attending. We look forward to your participation throughout today's meeting. I'd like to review the agenda for today. We have copies of the agenda and meeting materials can be accessed at the council's page of the Civil Rights Department's website at www.calcivilrights.ca.gov/Civil Rights Council. Highlights of today's meeting will include a Civil Rights Department report, council members' reports, consideration of final and modified text of Government Code Section 11135, regulations, a 2023 legislative update, updates from the council subcommittees, and further public comment. The first order of business is the approval of the minutes from our October 11th, 2023 meeting of the Civil Rights Council, which is could be found in attachment A. Do we have any council member comments or edits regarding the minutes from our last meeting? Okay, do we have any public comments regarding the minutes? No public comments. Okay, so can we get a motion to approve the comments?
I move. Councilmember Hong.
Alude, I second.
Great. Roll call, please.
Councilmember Glader has joined the meeting. Do we need to take roll for the meeting again, or?
We should. Yeah, we should acknowledge that Councilmember Glader has joined us, and so he's part of the process for approving the motion.
Okay, great, thanks. Councilmember Glader,
Aye.
Councilmember Hong,
Aye.
Councilmember Alude,
Aye.
Chair Sandoval,
Aye.
Councilmember Walensky.
Aye.
Great. Motion passes. I also wanted to take this moment to also acknowledge Monica Chavez, who's also part of the Civil Rights Department, who's joining us as well during this meeting. Great. So the next order of business is the council members' reports. Does any council member have any reports at this time? Okay. We're going to move forward with the Civil Rights Department report. I also wanted to make mention before we have the Civil Rights Department this week, we have United Against Hate Week, which is from November 12th to 2018. The Civil Rights Department is joining efforts across the state with regard to multiple projects and initiatives that our colleague Rachel Langston will speak about shortly. So Rachel, can you give the Civil Rights Department update, please?
Sure. So the CRD is excited to, in partnership with the city of Berkeley, Not in Our Town and LA versus Hate, we're excited to join government and community leaders for the launch of the 6th annual United Against Hate Week. The event is part of a call for local civil action to help put a stop to the spread of hate and discrimination, which remains a threat to our neighbors, towns, and cities. United Against Hate Week, which runs from November 12th to the 18th, was initially created by local government and community leaders in the Bay Area in response to white supremacist rallies in Berkeley and San Francisco, including at the site where the press conference will be held at the Martin Luther King Jr. Civic Center Park. The week is marked by individuals and community organizations coming together to host events and take action to help combat a national and statewide increase in hate. In California, reported hate crimes have reached their highest level since 2001, jumping more than 20% from 2021 to 2022. As part of the state's response to hate, the California Civil Rights Department recently launched CA versus Hate, a non-emergency multilingual hate crime and incident reporting hotline and online portal. So we are excited to be a part of this and invite you to visit the CRD website to learn more both about our participation in this week and about all of the efforts that the department and the initiatives that the department has made regarding hate crimes and hate incidents, and how we're trying to how we're available to help the community with confronting this increase in hate incidents.
Thank you, Rachel. Do we have any comments from any of the council members? Okay. All right. Thank you so much. I encourage you to look at the website to see how you might be able to participate with regard to this particular campaign against hate. So thank you again, Rachel. All right. So next up on the agenda, we have consideration of final unmodified text, proposed government code section 11135 regulations. I'll turn it over to my colleagues, council members Alude and Walensky.
Thank you, Chair Sandoval. So today, the subcommittee has not proposed any further changes, and we will be seeking today to make a motion that will request the council approve the final unmodified text to move forward to formal filing with the Office of Administrative Law. And we will also seek authority for the department to make any non-substantive changes that are necessary. Before doing so, I also want to, Councilmember Alude and I want to thank all of the staff members of the department who've been working with the subcommittee for their work on this, and also all of the stakeholders who have submitted written comments at each stage. And we appreciate and have considered those comments. I also would like to say that the subcommittee anticipates that if this rulemaking package is approved and moves forward, the subcommittee anticipates future rulemaking under section 11135. So I also wanted to share that as well.
Can you provide a little bit more information on what is it that you are conveying through the fact that there may be future rulemaking under this particular section?
Sure. So this is this proposed text is a voluminous and lengthy regulation. And so as with other rulemaking packages where the council has passed rulemaking packages and then have returned to particular sections or made further changes, the subcommittee anticipates doing so again here, given the length and complexity of the current package.
Thank you, Councilmember, for the clarity. I appreciate it. Any other comments from our fellow council members? Okay. Do we have any public comment?
No public comment.
Okay. Okay, so if the council approves this version, which is unmodified, it will be to authorize the Civil Rights Department to transmit the regulatory package to the Office of Administrative Law and to authorize the Civil Rights Department staff to make any non-substantial changes if required by the Office of Administrative Law. Do we have a motion?
I move. This is Councilmember Hong.
Thank you, council member. We have a second?
I second Councilmember Glader.
Thanks, Councilmember Glader. Need a roll call, please?
Councilmember Glader,
Aye.
Councilmember Hong,
Aye.
Councilmember Alude,
Aye.
Chair Sandoval,
Aye.
Councilmember Walensky.
Aye.
Great. Thank you. Motion passes. We're on to the next agenda item. And we have our colleague, once again, Rachel Langston, as well as Mario Block, providing a 2023 legislative update. Thank you, Rachel and Mario. Go ahead.
Thank you. I'm going to share my screen. We do have a slideshow that we prepared to sort of walk through what has happened during this exciting and busy legislative session. Give me just a moment to get that shared. Okay, is everyone able to see that? Great.
Rachel, you're not yet in presentation mode if you'd like to go into that.
Oh. I think that is a different window here for some reason. One moment. Did that switch it to presentation mode?
Yes, that's better. Thank you.
Great, okay. Well, as I said, it's been a very exciting, very busy legislative session this year. There are a number of statutes that have passed that will create some change in our department and in the civil rights laws we enforce, and we're excited to implement those laws. There's some other laws that, while CRD is not responsible directly for implementing, will affect or are of interest to our department. So I'll walk you through those briefly now. The first is Senate Bill 700 by Senator Bradford. This is a bill, if you remember, last year, Assemblymember Quirk put together, which passed and was enacted, AB 2188. And we'll talk about that in a moment, but it created a new section in the FEHA related to discrimination based on the presence of non-psychoactive cannabinoids in the system being revealed by drug screening tests, etc. This actually amends that new section. That new section was set to go into effect January 1, 2024. So both of these sections will go into effect at the same time. So SB 700 creates a new claim under the FEHA that prohibits employers from requesting information from a job applicant about their use of cannabis off the job and away from the workplace. Similarly, to the extent that employers request criminal background information for background checks, they may not consider any history that reveals prior use of cannabis unless they are permitted to do so through the Fair Chance Act or another law. There are certain exceptions where they can do that. And then finally, it does not apply to positions requiring a federal government background check or security clearance pursuant to regulations issued by the Department of Defense or other regulatory or other United States federal agencies. There we go. So this is what I started talking about a moment ago. So 2188, which passed last year, as I said, prohibits employers from discriminating against an employee based on the result of a drug screen that shows the presence of non-psychoactive cannabinoids. It also prohibits discrimination based on cannabis use at home or away from work. This is also in the FEHA, will also be enforced by the Civil Rights Department. And we will begin accepting intakes for these claims on January 1st of 2024. We also anticipate publishing guidance, FAQs in December. So next month, watch for that on our website. So this is the next bill that I wanted to touch base about. So Senate Bill 848 creates a new leave entitlement under the FEHA. And this leave is to be used for purposes of or after experiencing a reproductive loss. That's defined in the statute to mean a miscarriage, a stillbirth, failed surrogacy, failed adoption, or failed assisted reproduction, such as an unsuccessful artificial insemination or embryo transfer. This is a separate and distinct leave right from other protections, such as family medical leave and SIFRA leave or pregnancy disability leave. The employee is required to take the leave within 3 months of experiencing the reproductive loss. The one exception is if the employee experiences the loss while they're on a different type of leave. For instance, if they're on pregnancy disability leave and then experience a reproductive loss, they would have to take the reproductive loss leave within 3 months of the end of their pregnancy disability leave. So that's to make sure that they're, fully entitled and are able to avail themselves of both of the types of leave they're entitled to. The bill does not require documentation of the reproductive loss, and the employer is required to maintain employee confidentiality, and they may not retaliate against an employee for requesting that leave. Just as is the case with SB 700 and AB 2188, CRD will begin accepting intakes for this new leave claim, or for violations of this new leave right beginning on January 1st. And we again expect to publish guidance, FAQs, on this new leave entitlement in December. So Assembly Bill 1756 was the Judiciary Omnibus. And while it did many, many things pertinent to the Civil Rights Department, it extended our small employer family leave mediation pilot program, which was set to conclude January 1, 2024 to January 1, 2025. For those who aren't familiar, this program presents an opportunity for employees who have leave claims under the California Family Rights Act or the bereavement leave law, and to engage in mediation in sort of an alternative dispute resolution through our department, especially if their employer is a small employer, which is defined in the statute as having between 5 and 19 employees. And so they have an opportunity through this program to do that prior to filing a civil complaint. And there is a link where you can find out more about this program and generally the services that our department offers in alternative dispute resolution. Okay, so I wanted to talk a little bit about this bill, Assembly Bill 1228. This is not a bill that we will enforce, but it is a bill that we should be aware of. folks might recall that last year, AB 257, also authored by Assemblymember Holden, passed and was enacted. And it established or would have established the Fast Food Council, which we'll talk about what that does. And it would also establish a new minimum wage for fast food employees. There has been some opposition to this bill, and there's currently a referendum pending. So AB 1228 would go into effect only in the instance that this referendum contesting the act is withdrawn by January 1 of next year. So what this bill does is it sort of recasts and restates and cleans up a little bit last year's bill to describe sort of what the Fast Food Council would do and kind of its purpose. So among other things, the fast food, as I said, it would set the minimum wage, the beginning minimum wage, at $20 per hour beginning on April 1st of next year. And it would also notably create the Fast Food Council, which will be charged with establishing minimum standards for fast food employers regarding wages, working conditions, safety, training, etc. What is especially notable for us and for the council is that if any standard considered by the Fast Food Council falls under the Civil Rights Council's jurisdiction, the bill would require the Fast Food Council to file a petition with our council requesting that it adopt, amend, or repeal a regulation under its jurisdiction. And this is because the mandate for the Fast Food Council is relatively broad. Working conditions can include many things, and including some overlap with the laws that for which you all the council promulgates regulations and the department enforces laws. So we wanted to make sure that we weren't working at cross purposes. So in connection with that, the bill also clarifies that CRD will maintain its enforcement jurisdiction over the laws that we currently enforce, many of which do provide protections for workers, including fast food workers. So going back to laws that we do enforce or will enforce, Senate Bill 267 by Senator Eggman requires that, or it amends the FEOL to provide that where an applicant for housing for a rental has a government rent subsidy, housing providers are prohibited from using that applicant's credit history as a part of the application process without offering that applicant an opportunity to provide alternative evidence demonstrating their reasonable ability to pay rent. If the applicant opts to provide such evidence, the housing provider is required to give that person a reasonable time to do so and to consider it in lieu of that individual's credit history. And this, as I said, will also be enforced by CRD, and it will start accepting intakes as with these other new laws on January 1 of this year. Okay. All right, now turning to not necessarily employment, a little bit different. As you all know, CRD enforces and promulgates rules on affecting issues other than employment. So as we noted, the 267 deals with the housing issue that we enforce. Similarly, Senate Bill 727 provides a new form of relief for survivors of human trafficking. We also enforce the Civil Code 52.5, which this bill amends, and we investigate complaints of human trafficking. So this new protection would basically be a court order that the survivor could seek, finding that the trafficking victim incurred specific debts as a result of trafficking and without their consent. It also amends FEHA to clarify that our department may seek the above relief on behalf of a trafficking survivor in a civil action that we bring. Next is Assembly Bill 993. There exists a cannabis task force, excuse me, under the Business and Professions Code. And the task force promotes communication between state and local entities engaged in regulating commercial cannabis activity, and facilitates cooperation in the enforcement of state and local laws that are applicable to that activity. This bill adds representatives from our department as well as the Department of Industrial Relations to this existing task force. So we look forward to working in conjunction with other departments to provide our expertise in the areas where it is helpful to do so. Assembly Bill 1163, it amends the existing Lesbian, Gay, Bisexual, and Transgender Disparities Reduction Act to add intersexuality to the sorry, one second. Oh, trying to go back here. To add intersexuality to the voluntary self-identification information collected by our department and other state agencies. We are updating our intake form as we often do to be in compliance with these new laws and add these new rights that we enforce to the intake form and make that available to people. So we're updating our intake form to include intersexuality in our voluntary self-identification information that we collect from complainants. Assembly Bill 521. This is another bill that we don't enforce, but that does affect or could affect our existing regulations. So this bill requires the Occupational Safety and Health Standards Board to draft a rulemaking proposal considering a regulatory revision that would require all construction job sites to make available at least one single-user toilet facility designated for employees who self-identify as female or non-binary. It also exempts construction sites from an existing provision of the Health Code, requiring that all single-user toilet facilities in a business establishment, place of public accommodation, or state or local agency be identified as all-gender toilet facilities. Notably, the FEHA existing regulations that were put into place by our council also require, similar to the Health Code, that employers designate all single-user toilet facilities as gender neutral. And to the extent that that Cal OSHA or the board proposes regulatory revisions that conflict with that regulation, there may be some work for our council to do or some further consideration that needs to occur in collaboration between the two entities. So that's just, again, something that we're keeping an eye on and we'll update everyone on as as necessary if we hear more. So that's kind of the run of it, the new statutes that we will be enforcing and those that otherwise affect our department or our council. We would recommend considering a few potential regulatory packages to implement these new statutes. In particular, the new fee house section related to cannabis use, encompassing both AB 2188 from last year and SB 700 from this year. We also propose a package, implementing new leave entitlements, including the bereavement leave entitlement that was passed last year and enacted, and the new reproductive loss leave entitlement. And then we would also suggest considering a package on the new source of income protections put into place by Senator Eggman's bills, SB 267. So one thought that we had for your consideration is that the council might consider forming a new subcommittee to consider these and other new these laws and other new legislation to make recommendations about which, if any, rulemaking packages to pursue at this time or to pursue next year as we're sort of thinking ahead to 2024. So with that, I will turn it back to Chair Sandoval.
Thank you, Rachel, for that presentation. Much appreciated. Wanted to see if there's any council members who have any questions with regard to the presentation that was just delivered by Rachel.
I have one question. I curious about the small business employer mediation program, and wondered if you have a sense of how many mediations have sort of been conducted thus far, or sort of how that program has taken off.
We do have that data. I don't have it in front of me. Adam, I don't know if you happen to know off the top of your head.
I don't know the exact number off the top of my head. I think it's around 100 or so mediations or efforts to conduct mediations through that program. There have been some settlements, but we have found that parties have not utilized it, to be quite frank, as much as we thought they would.
I'm glad to hear that we have sort of another calendar year, hopefully, to see more utilization.
Adam, is there any information as to why you believe the parties are not using it in the way that you thought they would? Any initial thoughts on that?
I don't. It's a little hard to tell because for one, the statute of limitations to bring these claims was extended to 3 years about 5 years ago. And so we may not be seeing all the claims come in that are qualified for the program. We've worked very hard to get information out about the program. We have a set of FAQs, we have a web page, and it's included on all immediate right to sue complaints. Again, because of the statute of limitations, people can obtain the immediate right to sue, but they may not alert the employer to their complaint until sometime later that they choose.
Thank you. Councilmember Hong, you have a comment or a question?
I have a question. I'm just trying to, first of all, Rachel, thank you for this summary. It's really helpful to see what legislative action is really impacting not only the department, but also calendaring what the council should be doing in response to legislative action. My question is in terms of capacity and just understanding what that looks like. For the FAQs that you're working on, I'm assuming that's also you and Mariel, or is there other staff working on this?
It's kind of a collaborative effort, but our outreach and education unit is doing a lot of the work on that.
Okay. And then one of the items that you had talked about that's kind of pending was the Fast Food Council's regulatory impact on us, but that hasn't been formed yet. So I'm assuming should that happen, that's more like 2025, 2026, because they would have to make recommendations that would then we would be impacted. Is that correct?
Yeah, I don't know the exact timeline of when that would happen, but we'll definitely be keeping our ear to the ground and you know, following what they do and making sure that there are no cross wires and that we can you know, that we can collaborate to the extent or respond to any sort of petitions that they send our way with regard to requests of the council to make any changes, additions, etc.
Okay. And then, and I'm not sure if this is at this point, but I think my question is understanding that we have 3 packages that are going to OAL. We've put on hold the UNRU reasonable accommodation for social association disabilities and the religious creative discrimination. This other subcommittee to review possible regulatory changes. I don't know from a staff perspective if you guys could help prioritize like what is timely and having the most impact on Californians, or what would have the biggest impact in terms of urgency. I think that's what I'm struggling with, right? All of these items, and clearly we have a legislative impact on here. I'm just having a hard time trying to prioritize, first of all. And then secondly, understanding that, you know, staff have many different other responsibilities and that the council is 2 people short, right? So we don't do anything. And I know that so much of this is staff driven. I would just be hesitant to create another subcommittee without addressing, do we sunset some of these others, but really to look at the council's role holistically. And then looking at what that calendar looks like in 2024. And the last item is, you know, are these some items that we can help with outreach in the subcommittee of outreach, or how do we time this out? So that I think that's my long-winded question / statement.
Thank you, Councilmember. Adam and or Rachel?
Rachel, would you like me to?
Sure, I'll let
First, Councilmember Hong, I want to thank you for always being cognizant of staff bandwidth. It is a significant concern to make sure that, you know, our small team can get this work done and always meet the highest standards. Of the new legislation, I think another way to look at it is how much work may go into any of these packages. The leave entitlement, the new leave entitlements, the bereavement leave and the reproductive loss leave, we would not be writing on a blank slate necessarily, because the council already has CFRA and pregnancy disability leave regulations that could inform what any new regulations for these new leave types look like. And so from my perspective, those seem like a pretty low or light lift. The cannabis bill, I think that could potentially be much larger. And honestly, I think it would be premature to start a rulemaking on that immediately, because we don't even know what the complaints are going to look like coming in and what's going to be happening on the ground. I'm sure you will all agree that we want to respond to the issues that employers and employees and job applicants are actually facing and try to bring clarity where there might not be some. So I think that's one that could be postponed. With respect to the other packages, I think it's, again, an assessment of which you prioritize, the ones that got put on ice, which of those you prioritize, but also considering the size of the package. So the UNRU subcommittee, or writing the UNRU Act, that is a complete blank slate, and so is potentially a fairly large, complex, and new regulation that will take a significant amount of work. The religious accommodations, that was a proposed a very, I think, narrow package that the Supreme Court of the United States has also just issued a relevant ruling under Title VII that would, I think, inform what this council might or might not do. So that one seems like a fairly low lift. As Councilmember Walensky just noted, the Government Code Section 11135 Subcommittee does anticipate future rulemakings in that area, which is, I think, has historically been a priority of this council and could continue to be. So I think it's, we can help you assess, I think, the complexity and work that that a package will take. But among all of those options, we'd be eager to know from all of you what you prioritize.
Go ahead, Councilmember Hong.
I'm just cognizant that there's just 4 of us, and normally every subcommittee is 2. And just, I think realistic commitments, because I think we all have full-time jobs in terms of what we could reasonably commit to. Has there been any feedback in terms of where the other 2 vacant council positions may be filled from a timeline perspective?
I don't have a further update, except that the governor's office is working to fill the appointments, or excuse me, to fill the vacancies. Thank you.
Okay.
Councilmember Lude.
I just wanted to offer that before the subcommittee on reasonable accommodations for associational disability was put on ice, we were kind of given the mandate to wrap in some of the new leave changes that were in place. And so putting, both of those went on ice at the same time. It is my hope that sometime in the coming year, we're able to see some movement on associational disabilities. And it would make sense to me then that it would be paired with those changes in new leave benefits and regulation.
Thank you, Councilmember. I would like to. Go ahead, Adam.
Thank you for reminding me of that. I had forgotten that the subcommittee had its mandate increased, and so we could, while the administration continues to consider the associational disabilities package, work on the bereavement leave and the reproductive loss leave. And I do anticipate we're looking to bring on some temporary help into the legislative and regulatory unit. So I do hope we'll have some increased capacity in 2024. And Councilmember Hong, I just wanted to respond because I neglected to before. On the outreach and education front, if any of the council members would like to participate in efforts around these new laws, we'd welcome your participation if you feel like you have or can get expertise and the ability to present on it. Please be in touch with me directly. Thank you.
I'd like to echo the sentiments raised by Councilmember Hong. There are a lot of potential opportunities to move forward on different types of regulatory packages. And so it's important for us to kind of think through what is it that we already have moving forward. We have issues related to artificial intelligence that's moving forward, and incredibly important. I've seen different types of presentations over the last couple of months that it's at the forefront at the federal government. President Barack Obama was speaking about that issue at his Democracy in Action Forum, as well as the EEOC member speaking at that at an AWI conference, an investigation conference, and across the board. So I think that's incredibly important for us to continue to move down that path. I also would be interested to see what else we're going to do with regard to 11135, because if there are regulatory packages that are going to be moving forward, it's important for us, I think, to continue to focus on that as well, given the importance of that regulatory package and given the extent that it could affect different types of individuals who are interfacing with the government. So that could be, depending on what that looks like, that could be enough work for next year. Those two types of packages alone. So, and then any type of collaboration we do with the State of Hate Commission. So I really want to think through that more deliberately as we kind of identify where we go from where we are now. Any other thoughts from Councilmember Glader?
Thank you. I just wanted to follow up on Councilmember Hong's observation. It sounds like for at least some of these, we'll have more information in a few months, right? Once complaints will start rolling in. I'm wondering whether for some of these it makes sense to pause until we have a sense of whether, and then consider how to prioritize. I mean, I'm always reluctant to suggest kicking the can, but it sounds like here we might actually have more information.
Thank you, Councilmember. Councilmember Hong?
I apologize for my ignorance, but since this is my first time experiencing after we submit something to the OAL, can you walk through, we have 3 packages that are pending to go to OAL. If it comes back, I know we have a year's process. I just don't understand what responsibility the subcommittees may have in this next year once things are submitted to OAL. If you could, someone walk me through that.
I'm happy to take that, Adam, if you'd like.
Please.
Yeah, so really there's not, that's kind of a waiting period. We submit, the staff will submit to OAL. I mean, a big part of it is finalizing the final statement of reasons, after, and making sure that that's finished, and that the subcommittee is on board and, you know, makes any edits that they want to make, etc. So that's sort of the biggest lift right before submission to OAL. But when everything is submitted, it's kind of a waiting game.
Lost Rachel?
Yeah, why don't I pick up where? Oh, Rachel,
Sorry.
you froze for a moment. You were starting to say the waiting game.
Oh, yes. So it's a bit of a waiting game after we file with OAL. They have 30 days to approve or disapprove the regulatory package. They, what typically happens is within that 30 days, generally closer to the end of that 30 days, an OAL attorney will get in touch with myself or Mariel, whoever is staffing the package, and address any concerns that they have, either regarding the text of the regulations and the language of the final statement of reasons. At that point, it's a little bit flurried. It's not necessarily a lot of work for the subcommittee, but we do need to, you know, Mariel and or myself need to be able to get in touch with the subcommittee to kind of run these things by them, because there's a very short window once we have that last contact with OAL to finalize everything, respond to their comments, etc., and then turn it in. So we just kind of need to be able to access the subcommittee for thumbs up approval on these last minute edits that OAL has for us.
And if I could,
oh,
I
yeah.
was just going to give some more information on the 2 particular packages that are in play right now. The Government Code Section 11135 package, now that you have voted to approve, the unmodified text is in its final stage, and the subcommittee will have a significant amount of work over the next month to prepare the final statement of reasons with department staff, as Rachel was describing. And then if that subcommittee would like to begin new rulemaking efforts, you know, that could take a significant amount of time to start developing that new text in the new year. With respect to the automated decision systems, that's at the very early stage of the regulatory process. And so what we anticipate will happen in the next month or two will be the proposed regulations will be noticed to the public to start the rulemaking process. And so Councilmember Hong and Councilmember Glader, your subcommittee will have significant work all next year on the automated decision system regulations, which given the importance and prominence of this issue, I anticipate significant public comment. So I hope that gives you a sense of the two pending packages and the anticipated additional rulemaking related to 11135 next year.
Councilmember Hong?
Sorry, Adam, I'm confused because Councilmember Iglesias and I had approved the regulatory packet, the council had approved it in February, I thought. And so are you saying that we're going back to it?
Yes, the count. So what you'll recall is we did receive public comment on earlier drafts of the automated decision system regulations that we did through what's called a public workshop. We had not actually initiated the formal rulemaking when we received that public comment because we were trying to refine and develop the text before actually triggering the 1-year period. So in February, the council voted forward the proposed regulatory text, and because of the vacancies on the council and bandwidth, we have been working since then to draft the initial statement of reasons, which then would go to the Office of Administrative Law for noticing the formal rulemaking. So we're at the beginning stages of that package.
Thank you for reminding me. There's so many different calendars. I appreciate that. Thanks.
No problem.
Any other comments, feedback?
I was just going to say, from a staff bandwidth perspective and hearing this discussion, it seems like there could be consensus to restart this discussion maybe in the new year and see where we're at on new appointments to the council, additional staff in the department, and just postpone any big decisions. Obviously, as Councilmember Glader said, on these new legislations, we'll want to see what kind of complaints come in to again understand what's happening on the ground so the council can be responsive where necessary.
And Rachel, with regard to the guidance that's going to be issued, do you envision that at the beginning of December, in a couple of weeks, or the latter part of December?
I'm not certain yet. I'm
Okay.
kind of several cooks in the kitchen looking at that, so
Okay.
I can't give you a firm date.
And then I'm sorry, just to clarify, as we think about 2024 and cadence of meetings, I'm assuming that we're gonna have to be meeting in person again. Or will we be doing a hybrid Zoom?
That will be up to the council. If you'd like to meet in person, we can make those arrangements, budget permitting. There is legislation going into effect on January 1st that it does allow some more flexibility for teleconferences. And so I would imagine the council, as we have been doing, will have a mix of in-person meetings and some teleconferences where at least in those teleconferences, space for the public to come will be available.
Councilmember Luda, you had your hand up?
I had wondered about fair housing regulations, the cleanup a package that we were working on earlier this year, but I found the answer to my question, so there.
Okay. Thank you.
Just to bring everyone up to speed, those are pending final approval by the Office of Administrative Law. So those are at the very last stage.
Great. Councilmember Hong?
I'm sorry, guys know that I'm so process driven and I like to have structure. One thing that I would like to throw out is if it's possible, if it might be helpful, if to have like just a standing hybrid meeting so that we're not scrambling. I know that we have different packages happening, but as we think about planning for 2024, whether or not we can try building out a calendar so that we can plan accordingly. But that's just as a suggestion. Yeah. And then, my other follow-up question to you, Chair Sandoval, is whether or not, like, right, we have, if you've made any progress to see if we're gonna have a joint meeting with the Commission on Hate, as well. Sorry, I'm just really worried about calendaring and how busy everyone's gonna be, especially, I think we should be more, my personal opinion is that to be cost effective, we should do a hybrid and maybe do like 2 meetings in person if we have the budget, but I would prefer, I think for convenience and participation, online, as long as the public can participate, would be more efficient.
So Adam, in response to the items raised by Councilmember Hong, do we know what kind of restrictions, if any, that we will have with regard to having hybrid meetings or not? It's going to be any restrictions we should be mindful of?
Yes, the legislation authored by Senator Laird was enacted this year. I don't have the bill number in front of me at the moment. So we have the rules that we need to comply with to ensure public participation and public access. And so we can have these teleconference meetings, though there needs to be, as I understand, if I recall the legislation correctly, a physical location that does need to be available to the public, though not all council members need to be there, that you can participate remotely by teleconference. We're working with our general counsel unit to make sure that we're in compliance with that law for this council and for the Commission on the State of Hate. I think it would be very helpful to have a standing meeting if you all can find a regular time of the day, each the week or month, whatever is the right, for us to calendar it and just block it out, and then more than 10 days in advance, we determine if we need the meeting or not. And I say 10 days because that's when the public notice needs to go out. So if you could look at your calendars in 2024 and send Rachel possible windows that would be, always available for you month after month, that would be helpful, and we can pull those together and suggest some regular meetings.
I think that would be helpful. It's a good idea, and I think it's important if you want to be effective and efficient with our rulemaking and other items that we have on our agenda. So I do think that's good, and I think most of us, with some advance notice, we could plan and have a standing meeting. So I think that would be a good option. Councilmember Liddy, you have a comment?
I don't want to be difficult, but I think for those of us that sort of work on a litigation calendar, I don't know that we're going to be able to commit to being available at a set time and day going forward. I think the way that we've planned for meetings in the past and sort of checked availability when we had a sense of when we wanted to convene again has worked well for me. But I just don't know about being able to look that far out and be certain of availability, just because of the nature of the work that I do.
So in response to that, would it work? So my sense is that as long as if we have a meeting set up every month, right? So if for whatever reason it doesn't work for you, Councilmember Liddy, because given that your litigation practice, et cetera, that may be a way to address it, that if we cannot meet for whatever reason, or at that time, because of your schedule, for example, we could do the polling at that time to see if there's some other time that works with your schedule.
If that seems like the easiest mode, it sounds a bit more involved to me than the approach we've taken in the past, but if it's not sort of a burden to the staff, we can certainly give that a try.
Any feedback from staff on that approach?
I think whatever you all prefer, we'll make it work.
Okay. Anyone else? Regarding the feedback related to the State on Hate Commission, I did meet with them with Becky Monroe related to some data that's going to be coming out or has come out. I'm not certain. She said sometime in November. So to look at what are some of the trends with related to the calls that have been placed. So with that information, you could inform us as to what we can focus on. But again, this is a initial kind of a snapshot of what is being the source of the calls in terms of the types of incidents of hate that are being relayed. So that is item one. Item two is there is a agreement and a willingness to have a joint meeting with the State of Hate Commission. Of course, that has to be taken back to the State of Hate Commission, but there was some initial approval of it. And so that is something we need to look through as well. So is there a time, for example, next year that we want to have something like this take place? And then there's a third item that was outstanding from Councilmember Alude. She wanted me to ask whether or not there was going to be a hearing specifically on judicial candidates. As it's my understanding that the focus is going to be primarily on board members, school board members, other types of elected officials, but I did raise that as an issue with them. But it looks like the focus is going to be related to board members of educational institutions and not judicial candidates. Councilmember Hung?
I found this on the web for a hearing specifically on judicial candidates, as it's my understanding that the focus is going to be primarily on board members, school board members are the types of elected officials. But I
don't know how that happened, but it happened. Remember?
Speaking to Councilmember Alude's point, I hear that. I think one thing that I could do is just have standing meetings with Councilmember Glader on AI. I think what I struggle with is kind of the scramble when one package is ready to go and no one else is aware of it, and then all of a sudden we're scrambling for a meeting and there's all these doodle polls, which seem like a big lift for staff, and then trying to carve out time. So for me, it was more like bringing a cadence to our meetings and some regularity. But I totally respect the fact that you have no control over your calendar as a litigator, but also understanding that if we have the majority, then we can move forward. So that I'm totally open. I would defer to staff how much time they're spending trying to scramble for meetings, along with, just the cadence of all the other packages. But I'm totally open, and this is something that's probably more personal preference. And so I don't want to force anything upon everyone else.
Councilmember Walensky?
At the risk of belaboring this discussion, I agree that for me, advance notice would be helpful to have a standing monthly time that we hold for meetings, but with the knowledge that as packages move forward in the process, the meetings get closer together and slightly harder to predict when exactly they will be. And so I think that just happens because the comment periods get shorter and then the timelines get compressed. So I like the idea of having a monthly hold for a spot, with the idea that it might get canceled or moved or have more frequent meetings as packages progress.
Great. Any additional comments? Thoughts? Okay. All right. So with regard to, I guess as part of the next item as well, I think kind of blended the two. But the next agenda item is subcommittee updates. Are we done? Are we done with the last item? Do you think? Okay, subcommittee updates. Do we have any subcommittee updates? Okay. All right, so as I understand it, we're going to wait with regard to the regulatory packages that might be needed given the recent legislative action dealing both with the use of cannabis as well as the two types of leaves, and that will be informed in part by what kind of complaints are being received by the Civil Rights Department to better inform the types of work that needs to be done on the regulatory front. We also are waiting to see there may be an additional appointments to the Civil Rights Council that could also better inform our 2024 agenda. There's also agreement, and now we need to confirm a date when we have a meeting with the State of Hate Commission to be determined where and if that. My preference, of course, we could talk about it, is to have that in person with hybrid, right? Somewhere that we've talked about in the past as being one of our meetings that are in person. And then I guess we'll be moving forward related to issues dealing with artificial decision-making or AI at the commencement. We also have potential work under 11135. And then we need to have a more robust discussion in the new year about what is it that we are going to be focusing on, including those regulatory packages that were put on ice or on hold, however you want to describe it, in the new year, which I think would mean hopefully that we'll have a council meeting in January or early February of next year. Any additional thoughts at this time on anything related to subcommittees? Do we have any public comment on this item?
Yes, we have one from Rita Loof.
Okay.
I think Rachel, you might have to unmute. Yeah.
Go ahead, Rita Loof.
Good morning. My name is Rita Loof, and I really appreciate the work that your council is doing. Just FYI, the name of the title of the legislation that allows for hybrid meetings under the Bagley-Keene Act is SB 544 Laird. I wanted to share information with you because I'm a parent of students with disabilities who's been dealing with the special education system for over 20 years. So I very much appreciate the comments made by Member Aludi to revive the Committee on Disabilities. I would like to tell you about the barriers to education of children with disabilities. Our children are being denied access to education, which will result in them not having equal access to jobs and society in general. I've witnessed how the special education system has been hijacked by for-profit law firms representing school districts who are acting as a barrier for our children to get an appropriate education. I have recently filed a complaint against the Upland Unified School District with the California Civil Rights Department. And I'm here to share the experience and ask the council to help in correcting a grave injustice that is being perpetrated against students with disabilities. Currently, most school districts do not follow the Brown Act requirements for approval of litigation related to students with disabilities. Our children are being treated as second-class citizens because the elected officials are literally washing their hands and are not representing our children. The public has no idea that millions of dollars are being spent every year in California to sue kids with disabilities to deny them very basic services. These millions of dollars were supposed to be used for the education of our children. not for litigation. And many school districts like Upland Unified School District hire for-profit litigators to conduct surveillance on families of students with disabilities. I've had experience with that myself, to file lawsuits. My family has been sued. My children have been sued by the school district multiple times. And this is not what taxpayers intend. So I thank you for your work. And I really hope that you can embrace this issue and that we can partner together to improve outcomes for students with disabilities in California. Thank you.
Thank you, Rita Lou, for your comment. Do we have any other comments, public comments? On the side?
Yes, we have IEP mom. Rachel, can you unmute?
Hi, go ahead. Individual identified as IEP mom.
Hi, I want to echo everything Rita Loof has said. I am also a parent of children with IEPs with disabilities. We have very, very similar issues. The school files due process complaints against us to retaliate and harass us and intimidate us from using our voice and advocating for our children. If we file complaints with CDE, then we have more retaliation. They use certain law firms that seem to have a lot of influence with CDE and OAH. Once this law firm started responding to my complaints to CDE, CDE stopped siding with us and started siding with the school, even though the violations were very clear violations of IDEA. When we were filed, when a due process complaint was filed against both my children, OAH changed policies and procedures to accommodate the counsel instead of the parent, violating my due process rights. As parents, we cannot even compete. One, we don't have the state funded attorneys. And two, once the attorneys get involved, CDE and OAH seem to be biased towards them. It is the request that the issues that we have for my children, we have evidence, we have data that they need the services. However, the school would rather pay high-priced attorneys to fight for those basic services than provide them. This means that my children will grow up with a greater and greater gap and continue to need more services than less services. I'm concerned every day about how I'm going to help my children. We don't know where to go or who to turn to. All the agencies that are supposed to help us do not help us. The Health Self-Us don't help us. CDE doesn't help us. OAH doesn't help us. The schools put communication plans on us so we can't even use our voice and have parental participation. There's no accountability. There's millions of dollars going into the schools to help our children, yet we are being denied basic access to general education and their special ed rights. We need someone to listen to us and provide us an avenue to access our rights. The laws are there, but we have no access to those laws. We appreciate what you're doing, and we ask that you look at these issues and help us to access basic due process and IDEA rights for our children. Thank you.
Thank you for your public comment. Any other public comments?
Yes, we have Pam Ragland. Rachel, can you unmute?
Thank you for unmuting me. I want to thank you for this forum. I didn't even know you existed, and I'm super excited. So we don't want to feel like we're ganging up on you, but I want to echo the last two presenters and let you know that I've had 17 years of fighting for my two kids. I was sued multiple times and I sued back. I started learning to win. But my background is also in transforming Fortune 100 companies, and also litigation against banks. So when I got into this, I said, why is there so much suing going on? Why is there so much fighting going on? And what I determined is that we have, as the other speakers have said, certain law firms who have solicited the school districts and said effectively this: we're going to teach you how to fight the parents. You pay us this much money. We're going to teach you how to fight the parents to keep from providing the services that you're legally obligated to provide. And I can hear someone maybe who needs to mute. So this is very concerning to me, because what I see is we have an organization, OAH, who's tasked with doing administrative law for these schools. We now have a decision that's not a binding decision, it's an opinion from the Attorney General blocking advocates from running due process hearings. So parents have to pay one set of advocates to advocate in their meetings. And if it gets to the point where the school refuses to do anything but go to a hearing, now they have to find an attorney to help represent them on their own dime while the schools are using taxpayer money. And these attorneys are doing things that actually violate the bar. So when I got into this, I was like, oh my gosh, I feel like I'm fighting a bank, except for these are schools and these are kids. I now have a group of thousands of parents, and I'm going to tell you, at least 25% of our kids in this state have dyslexia, but they are not getting the services that they need despite the newest legislation that came down the pike. And this is going to be a continued and expanding problem. And I really think we need to sit back and rethink it. And for example, if I help a student with dyslexia in kindergarten or first grade, maybe they're not even ever going to need mitigation. They just need certain services to help them. By second grade, they're going to need more. By sixth grade, they're going to need more. By ninth grade, they're going to need more. This is actually costing the state money to do business this way because of all this fighting. So I personally would love to partner with you in some form or another, use my experience. I've been appointed for 10 years. I ran for election. I would like to, for us to be able to partner together to solve this really big problem that ultimately the state of California is not only not going to be able to handle, but we could actually we're right now risking losing federal funding for special education because we are not compliant with the federal laws. Our whole process to eliminate advocates from due process is not legal. So anyway, that's why I'm here. Thank you for listening. I'm also familiar with the UNRRA Act and that legislation or that law itself. So we appreciate you listening. This is a huge opportunity. Of all the disabilities in our state, I'm going to tell you the special education disabilities are the biggest, and it really needs to be addressed.
Thank you, Ms. Ragland. Any other public comment?
Yes, we received an email public comment from an individual, Leah Naomi Gonzalez, and this regards several of the individual complaints that they filed with us. Just want to note that this is a rulemaking body, so it doesn't have information on individual complaints, but we have received the comment.
Okay.
Next commenter is Concerned Parent. Rachel, can you unmute? Concerned Parent.
Hi, thank you so much. Can you all hear me now?
Yes, we can hear you fine. Thank you.
Okay, thank you so much. I'm very impressed with this committee to see that you only have 4 people. Obviously, you have an awful lot of work to do, but I very much appreciate the time to be able to talk about some of the issues with special education as some of the other commenters have. Unfortunately, I am going by Concerned Parent because I have been retaliated against multiple times by Irvine Unified School District, as have unfortunately many other parents, simply for asking for our children's state and federally protected rights. Irvine Unified, for example, obviously gets state funding. And as has been discussed, mentioned previously, a lot of that state funding is going directly to private attorneys to actually sue our children or to withhold services, forcing parents to sue the school district. And if you think about it, it's an inherent conflict of interest. These private law firms were coming in saying, oh, we will be your advisor on special education issues. And guess what they advise? Pay us up to $1,390 per hour, which was in an actual contract with Irvine Unified School District and a law firm. So you pay us up to $1,390 per hour, and we will get money, win or lose. And we will, of course, the conflict of interest is the attorneys always advise to sue or to keep disputes going because they are paid by the hour, win or lose. And this is a fundamental flaw in the system. The school boards rely on these attorneys, and the school boards are not even approving litigation against our children. That is absurd, and that in itself is discriminatory. School boards have to approve all litigation, and they do so with teacher sues, or if somebody slips and falls, they approve every single type of litigation. They even approve suspensions and expulsions. But for some reason, kids with disabilities are just invisible. They are just handed off to these private law firms, and these private law firms basically put a target, and they put a price on the head of our children with disabilities. And they might see one child with autism and think, oh, that one might be worth a couple $100,000. We could even go all the way up to the Ninth Circuit with that child. Win or lose. This is what's happening in our education system, and it's really got to stop. And the Office of Administrative Hearings is contracted with the state. That they are contracted to provide neutral mediators and hearing officers. And yet parents only win about 25% of the time, if even that. It is a completely biased system. Most parents, do not have the money to hire attorneys. They don't have the education. They certainly don't understand state and federal laws. I've been a 20-year advocate for children. I have run a nonprofit organization for children with medical and special needs. The vast majority of parents cannot possibly learn all of these laws overnight and represent themselves. So I want to thank you very much for this committee. We want to bring to your attention this huge concern about students with disabilities who will soon be adults with disabilities that have not been corrected or remediated. And that is going to be a huge burden, and is a huge burden to the state of California. So thank you very much for allowing me to speak. Thank you.
Thank you. Any other public comments?
Yes, it just says iPhone. Can you please identify yourself?
Hi, I'm the iPhone mom. I would like to echo everyone spoke here today, and last mom that she spoke that we have a children who is graduating, aging out without school support. I just want to say I am that mom who is speaking English as a second language, which does not know how to even navigate the school system. I feel threatened every time I go to the IEP meeting for children with a disability. I get huge anxiety. I lose my hair. I don't have a glorious word like other moms does, but I can tell you from my experience, it is such hardship, the pain that I have never endured my whole life, having a child with a disability. When school's supposed to help us, they hurt us. They keep our children being more disabled than when they enter the school. My child, who is 18 years old, at age 5, she was signing and she was speaking when school told me that my daughter has such a huge disability, the support services, that's not gonna help. So they're not even giving basic civil rights of my child speaking language that she spoke. They forced the communication that she is not used to. Everything is foreign. They deny all the services. Instead of using money to help our children, they are giving money to the lawyer, and the lawyers are having this is a huge money-making process. I don't know how to even tell you the pain that I, as a mom, endure. Cannot sleep at night. My child's gonna graduate, but she does not know how to even communicate. Even now, that communication is being denied. Sign language is denied. And but if you are advanced, typical child who just need a little bit more tutor services, school will offer that tutor services because they want to make sure their school scores are being better. But when child with a disability, it's not showing it anywhere in their report they have to submit it to. So they just put it under the rug and house my child in 4x4 wall, and she stays in that classroom all day long. So bottom line is what's been happening 20 years and same is happening 20 years now. Even the state is pouring down all this amount of money, but it's not going to our children's education. It's going to the administrators' salary being increased, but there is not an increase in services. And thank you for listening. I know this is your second job, but we are relying on, mom like me is relying on you for you to advocate for our children as well. Hear our pain and the stories. Me as a mom lost all my hair during COVID because I simply did not know where my child's gonna be. And if me as a mom trying to talk to school about this, school is constantly trying to put institutionalize our children when there should be an inclusion. And we need to stop this. Please help us. Thank you.
Thank you.
Next is Tao Tran. Rachel, can you please unmute?
Hi, can you hear me?
Yes.
Hi there. Thank you so much for having me here. I am a former correctional staff and a parent, and currently a parent of a child with a developmental disability. I have done nothing wrong but serve as a parent who wants to be informed to make the right decisions for my child's future, so that we will not see her be medically institutionalized. We don't want to see a repeat of Willowbrook State School in New York, or place her in prison. But at the age of 3, my child was already thrown into a very restrictive learning environment with no aid and adequate support to help her thrive. Every single time I hear from school district, no, no, no. Okay. But the federal law makes it very clear that school districts must consider the least restrictive setting to support the disabled child. She has never seen in her, now she is age 7. She has never stepped more than just 5 minutes during her time at school, being around non-disabled peers in an inclusive setting. At the age of 5, my district has pushed me to not communicate with me on open ground. I was retaliated by being placed on a communication plan, which unfortunately, with Ms. Debbie Cam and some of the parents here, we are on a communication plan, and they actually allowed this to take place. But this communication plan was not only seen to me as a curb on my ability to communicate freely with all direct service providers, but now I have to go through the administrator, as well as the district legal counsel to review all my emails. Sometimes the intent of my email is so filtered that by the time I get a response, it's already fleshed out by a district. At the age of 7, my child's current age, she is not allowed to have access to a higher word power. This is a non-speaking child. Access to appropriate speech intervention will help my child have a better quality of life. But instead of helping me and collaborate with my professionals from Stanford Children's Health, the school district has denied me numerous times. And there was a time where they faulted me for wanting to help my child. I have asked under the Public Records Act to see how much services are being spent on my child's services and how much was spent on hiring their district attorney to attend most of my IEP meetings this past year. The district continues to not provide me that transparent data. They want more money. They want more money. They want the public to give schools more money. I know there's money, but the problem is, where's the money going to? We don't want more. We want the money to go to attorneys. We want our kids to have an education, to give them hope so that they can be like Harvard's University first deaf-blind graduate who is not only deaf and blind, but shattered, but able to provide her a unique disability lens to make our world a better place. Thank you.
Thank you, Ms. Tran. Any additional public comment?
Yes, next is Tanya Whiteleather.
Go ahead.
Thank you. Hello, my name is Tanya Whiteleather. I'm an attorney and proudly a credentialed teacher. I practice special education law up and down the state of California. And what you have heard from these parents here today is what I find in almost every single school district. I realize the council's position and that you cannot specifically make any changes in all of this. And I appreciate the hard work that you do because this is a lot of work. My biggest concern is that we have a hearing office that over the past year or so, I have discovered is not even legally serving parents, sending things out electronically. I'm just trying to let you know what we found. There are requirements that the hearing office give out surveys, and this is part of their job, and they won't do that. So that they can keep track and have record of their performance of the administrative law judges. We have not been allowed, following the opening up after COVID, to have hearings. I cannot confront witnesses. Again, I know that you folks don't have the authority to change this. I am letting you know how bad things are in disability land. We have, as somebody mentioned, an attorney general opinion, which really says that each agency can determine who may assist or represent. And we do have a federal law that says parents may be assisted and advised by anyone. But OAH has decided that that doesn't apply to children who are 3 through 22 in special ed land. But it applies to children under 3. So if you're involved in a regional center case and an advocate, you may assist the parent and speak for this child or parent at hearing. It's a skewed system. We have big firms who are pushing and will run up the bill and push when they could have settled and lose. Or if they even win at OAH, when we get to the federal courts, they settle because their positions are so bad. But against a parent who is not trained in the law and not trained in special ed, doesn't have the resources, doesn't know how to do a hearing, it's terrible. And I have seen many students over the 30 years I've been practicing who have been given appropriate services. There are good districts, and most teachers come out of this beginning they come into teaching because they want to help students. It's just, most teachers are basically good people, but they get caught up in the system and told what to say or not say. But students get the help they need. They go on to become productive citizens. They are able to get a job and keep a job. I always tell them your job is to get a good job and support your parents. And they laugh and give me wide eyes. But we want them to be productive members of society. And for most of my clients, that's possible, but it's not possible with what's going on. Again, thank you so much for all you do. Your time is valuable. Your help and advice and monitoring of what's going on. It was fascinating to sit through and listen to all of this. It's wonderful. It's necessary. This is a corner of California that is bad. And I appreciate just letting me share with you what we have. And if anybody has any further suggestions, we've been trying to get OAH to listen, not getting anywhere. And I think we're going to be talking to CDE, but people with disabilities, students with disabilities in this state are being badly, badly left behind. Thank you.
Thank you, Ms. Whiteleather. Any other public comments?
I think just confirming we still have hands raised from IEP mom, but not sure if this person still has a comment. Maybe we can unmute.
IEP,
mom.
do you have any comments?
Yeah, no, I did. I wanted to add a comment. My background is I have a master's in education, and I was an administrator and educator in K through adult. So I have a teaching credential as well as an administrative credential and worked with at-risk kids. So one of my concerns is I'm in everything.
IEP mom, you're cutting
We
out.
all choose for schools. Can you hear me now?
Yes, we can.
Can you hear me now?
Yes.
Okay. I wanted to make sure that that you understood that these issues are also with charter schools. We have a auto charter SELPA that governs most of California, and the charter school that my children now attend because they were assaulted and harmed in our Fresno Unified School, and they're now an El Dorado charter under El Dorado charter SELPA. This is very similar to all the other issues that you're hearing. My children have a vision, one of them has vision impairment. They have dismissed it, refused to recognize it, refused to acknowledge it exists. So my child doesn't have access to large print materials, to accommodations, to anything that would be given some vision impairment. My children have dyslexia. I have 3 children with dyslexia, a senior that just, and they're all in the high average IQ range. Just graduated with a 4th grade reading level. My 4th grader is at a K reading level. My 2nd grader is at a pre-K reading level. And this would be a simple fix to just provide them the structured literacy intervention that they need at the time that they need it. If they refuse to do that, they'd rather hire an expensive law firm to fight and not provide. My children do have a on their head. Recently, we were offered payments to provide the services that data say they need, their own schools reports say they need. If we will disenroll our children, they will provide a settlement for us to leave and go away, and never return. So obviously they understand the need. They have the funds, but they just want us gone so that we cannot continue to receive the services from them. There's something wrong here. And when I reach out to the SELPA as well, it's dismissed. There is systemic issues from the LEA, the SELPA, the CDE, and the OAH. And we need someone to look at these issues and address them so that our children can have an opportunity, as their peers have, to be successful, productive citizens. Thank you.
Thank you.
I think we have Jay Fisher. And we should also reiterate time limits. Comments are limited to 3 minutes. So we'll be letting you know.
They all have been
Hello, ma'am. Okay. Okay.
Go
Hi.
ahead.
Hello. My name is I am a bilingual mom, and as a parent with a second language, I have experience first on how we are often treated poorly within the school system. We were given inaccurate information, and then we do not know what's going on with our kids. Next thing we know, our kids was separated and having a behavior. The school continuously neglecting our concerns that we do not understand of what's going on. A translation of the documents was taking so long, and then we have to always write from time to time to translate them. And when we request them to be translated, they would say, "Oh, that would take time. You need to sign this first before we can translate it." So because of this, it's delaying more of the services of the kid. And another thing is not only having second language is a challenge, the parents also has disability. So when we request an accommodation, we express about under the ADA law, the school will continuously limited our participation and not even providing what was requested. And because of this has been difficult for us. And when we ask them, when we write them, constant communication to understand this, they will not respond. There will be a retaliation. Sometimes there will be a use of power. There were times that we would see there's like police in front of the school, but we were not informed why there's a police. Was there any threat? And when we communicated this to the school district, next thing we know, they were not there at all, and even other parents have not seen it. So we have exhaust our time of communicating to CDE, OCR, and other organizations, our legislators, but in the end, nothing was being done. In the end, we were just taught that are recognized or acknowledged as a parent that are frustrated. But the fact that we are not being heard, we are not given an equal rights to understand how they are treating fairly our kids is not right. But all we got is retaliation and intimidation. So we hope that you listen to us and you give us a chance to be heard, because when we don't have anyone, I don't know what's going to happen in our community. And that would be all. Thank you.
Thank you for your comment. Do you have any other public comments?
Tao Tran, do you have another public comment, or was your hand still raised?
Can you hear me?
Yes.
Yeah, I want to say these words that I leave you with this final note. During my time in the federal correctional system as one of their staff, we spent nearly $50,000 on average.
Ms. Tran, can you hear me?
Can you hear me?
Yes. Can we make sure other folks who have not commented first, if there's anybody else, and then we'll let you speak. Mario?
Yeah, I can speak later. I'll let others speak first.
Yeah, I think
I believe that everyone is a repeat commenter. Yeah.
So, Ms. Tran, if you can continue, just a reminder, we have a 3-minute limit for folks to speak. So if there's no any additional public comments who have not spoken yet, is that true, Mariel?
Yes, I believe so.
Okay. So Ms. Tran, if you could move forward, go ahead.
Yeah, sorry. I'd like to leave you with this final note that during my time as a federal correctional staff, we spent nearly $50,000. This is about 5 years ago on an inmate. And for the medically complex inmate, we send them to the Federal Medical Center, which can cost as much as $100,000 just to take care of a very sick inmate. Now, a child, in terms of federal dollars, a child with a disability, we are spending $30,000 to $40,000 a year. Can you justify why are we not? I'm just saying in general that why our investment is not being spent to help our kids at a very young age so that they have a better opportunity in life. But waiting for the problem to not be addressed, the unaddressed mental health problems we see on the news, the shooting, kids who cannot read, all these issues that we see, and wait for that to to become worse and then put them in prison. If we can prevent that from happening and focus on when they're young, give them that opportunity to grow and give them hope, because like one of the lawyers said earlier, these kids with disabilities, they have skills are waiting for us to tap and let them bloom. But when we don't give them the opportunity to grow and learn using these creative approaches, they call them universal design learning framework, it's really hard for them to really make it in life. So let's save a life. Let's not put them in prison. Focus on them during the early years from K to 12. Give them the chance to have a better life. Thank you.
Thank you, Ms. Tran. That's my comment. Any other public comments?
Yes, Pam Ragland.
Ms. Ragland already spoke. Is that correct?
Yes.
Okay, I think any additional comments?
Yes, one more from iPhone, who I believe has already spoken as well.
Yeah, I want to get some direction from staff. I think everyone has spoken already, so we could continue to have 3-minute increments, and then it'll turn into much more time focused. So, Adam or Rachel, what process should we employ here?
My recommendation would be, since we have already begun allowing people to speak twice, that we continue with that. It would have been your prerogative to limit people to one comment at 3 minutes each, but since we've started on the double commenting, I think we should continue.
Right. Ms. Ragland, go ahead.
There you go. I'll be fast. I just wanted to add a couple more things, and thanks for listening to us. We really appreciate it. I did a Public Records Act request for one of my parents. The school had spent $35,000 fighting over $10 a month. I just wanted to quantify some of what we're seeing, and that was without going to any kind of a hearing. Personally, I got into this when my son was kicked out illegally with a gun, and I felt that I needed to learn the law myself, besides litigating against banks. But I want to make sure that everybody knows, when I made the comment about dyslexia can affect reading, writing, and math. So the things that we created schools for kids to learn reading, writing, and math, I'm seeing at least 25% of our kids cannot do. And some of these kids also have autism and ADHD, and some of them do not. And these kids are really falling through the cracks. And for whatever reason, the Common Core methods, educational methods, do not work for them. But the educational methods that do work for kids with dyslexia, the other kids could learn. So I think there might be some simple solutions here that could really go a long way towards helping a lot of these kids. And, to that end, I don't know if you guys have the authority or power, or you're just reviewing legislative packages, but it seems like having a committee that's directed towards special needs for our students in our state could really make a big difference, not only to our kids and their learning, our placement in the educational arena across the entire United States, but actually how we're spending our money, our tax dollars within the state, in addition to really helping these kids improve their lives. And, when I really figured out how to do this, my son increased by 9 grades in 1 year. It's completely possible for these kids to learn. They just need to be given the right way to teach them. So thanks for listening.
Thank you, Ms. Ragland. Meredith, there's another.
iPhone, please go ahead.
Hi.
Hi.
Yeah, the
Hi.
person, iPhone, go ahead.
Can you hear me?
Yes.
Okay, thank you again for letting me speak again. But I thought maybe I need to be a little bit more detailed, since other moms have communicated with their child. My child is nonverbal. She's communicate signing. This is a basic human right to speak. The language, school have denied it for 18. Oh, well, from first grade all the way to the 12th grade. My child is in 12th grade. I'm spending my own money to get a signing tutor and teach my child how to sign. School currently still deny signing, but as a typical child, they're able to go to the signing class and learn signing as a second language. But whereas my child cannot speak, cannot communicate, basic human rights have been denied by school, and they told me that's not, they don't have to provide that services. Apparently, my daughter was caused harm by school because they don't want to go figure out how they're gonna teach my child. So even basic human right is being denied, and institutionalize my daughter. She's in 4x4 wall along with many other children with the special need. They're all together from 9th grade all the way to 12th grade. They're in the same room all day long, and they're being educated for same thing. Even though my daughter have a different specific need, they're not teaching her signing. They're teaching her what's going on in the world, news. So this kind of education is being done. Our children are neglected more so than anyone in this world. Basically, they're in a like were sent to different country to learn how to even navigate in a different country. They have a chain in their leg, individual chain, that they cannot, as a United States citizen, cannot go to the right places freely because they have individual chain linked into their leg, just like a Texas chain of the prison. That's what they have. When they said they're going to integrate into our children, they line our children, and then they have to go one by one. When they say there's an integration, you can clearly see our children are at the corner where nobody wants to sit, but atypical children have obscene amount of support.
Thank you for your comment.
Thank you.
Mariel, anyone else?
So it appears that okay, the hand just went down. So I think that's all of the comments now.
Okay. All right. So I think that was the last agenda item. Is that correct? Okay. So we have no other comments. Is that correct? From anyone else, Mariel?
There are no other public comments.
Okay. All right.
Oh,
well,
I'm sorry. A hand just raised. Viviana Barnwell.
Okay. Proceed.
Hi, good morning. I just joined. I'm sorry. I just wanted to add really quickly to what I was able to hear. It's not my child, because you hear every mom saying my child. I have a child who has multiple developmental disabilities. I am a member of the California State Council on Developmental Disabilities. However, I'm speaking as a parent and as a parent advocate. I wanted to clarify that many parents say my child, but from the perspective I have supporting other families, it's everybody's child. Every child who's in the special education program goes through the same kind of issues. I currently have a complaint that I filed with the Civil Rights Office because my son was discriminated during a field trip. And field trips are another issue that children with disabilities face, as schools many times ask the parents, if you're not going, your child is not going. Of course, in nice ways. Of course, not in written form. Also, my child, for example, has a one-on-one aide who was not sent to the field trip because the parent was present. That's another thing they do. So the alignment with IDEA is minimum. We are always conditioned for our children to be part of anything beyond class. And as someone just shared, in a very segregated way, and many times we have to buy into inclusion. That includes children with food allergies, which are also part of ADA. So I just wanted to clarify that when parents say my child, they are speaking about everyone's child, because most children, if not all, go through the same discrimination, segregation, and that includes activities beyond the classroom, in particular field trips. Thank you.
Thank you, Viviana Barnwell. Any additional comments?
Do not see any additional comments.
Okay. I'd like to thank everyone for participating in today's council meeting, including our stakeholders. Also like to express my appreciation, as always, to the Civil Rights Department staff and my fellow colleagues. It is currently 11:56 a.m. and this meeting is adjourned. Thank you, everyone. Have a good rest of the week. Bye-bye.